First in our 16 webinar series, Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LL.M program, in which Catholic University has cooperated with Jagiellonian University in Kraków, Poland for many years. I will be your moderator. To open, I now turn to Stephen Payne, Dean of the Catholic University Law School, from greetings from our law school.
Thanks so much, Leah, and it's a pleasure to be here with all of you. I applaud Professor Wortham for her leadership from our end in putting together this particular program, which is, she'll say, a big team effort, but also on her efforts to foster community among both Catholic law and the best law school in Poland, Jagiellonian University. I really appreciate the deep roots grown over almost 30 years our two schools share, begun through the great efforts of former Jagiellonian University faculty member and our Professor Emeritus, Rhett Lubikowski. I had hoped to celebrate the relationship with you in person at Jagiellonian last June, but those plans, of course, were scuttled by the pandemic. I hope to visit sometime soon. I especially want to thank my esteemed colleague, Dean Pisulinski, and Jagiellonian's whole team for your partnership with us. It is important and meaningful to our school, and we really appreciate it. I know that this series of programs will be rewarding on the merits to those who are interested in the topics and are able to participate. We have great panelists today, but I also hope it continues to foster the kind of community we strive to have with you, finally connecting more directly and appropriately with our Polish LL.Ms, our International Business and Trade Summer Law Program alums, and our American Law Program alums as valued alumni of our school, and opening up a shared global perspective with you and your international expertise and experience for our domestic JD students and alumni. So I'm thrilled you're here with us. I'm glad to be with you. Welcome, and thank you for participating.
Thank you. And I now will ask Jerzy Pisulinski, Dean of the Faculty of Law and Administration of Jagiellonian University, to bring his greetings as well.
Good afternoon or good evening, everyone. So thank you for invitation, and I'm very glad that we can start this project, the series of webinars, with the contribution of Marc Liebscher, who lived in Kraków and worked at Kraków for many years, and he has been promoted as a doctor at the Jagiellonian University. So this is a small symbol of our internationalization and cooperation with different universities, different partners. So in 1997, we started cooperation with Columbus Law School. So Leah supported to create in Kraków the first students' clinic in Poland and in Eastern Europe. Since many years, we cooperate in the frame of summer business law program, or with the program of American Law School for Polish students. So I would like to thank you, Leah, and to all members of the faculty of Columbus Law School for your efforts and for cooperation for many years. We would celebrate 20th anniversary of summer law program in Kraków in June. We would celebrate a special award given to Red Ludwikowski. However, it's not possible. It was not possible. So I hope that next year we can meet in Kraków, and I would like to invite all alumni of the American Law Program and of the summer law program to Kraków for June next year. I hope that it would be possible. So thank you again, and I'm very honored and I'm very pleased, Marc, that you can join us and present your contribution today. Thank you.
Thank you so much. So 2 hours before this webinar, 267 people had registered. We're delighted to have so many participants from both sides of the Atlantic and hope those numbers will grow over the 16 webinars. Many people at Catholic and Jagiellonian universities have played important roles in bringing this series to fruition. I will quickly acknowledge a few of them before introducing our distinguished speaker and commenter and turning to the program. Professor Piotr Szwedo, the Jagiellonian Director of the Center for Foreign Law School Cooperation, often referred to by its Polish acronym OXPO. Wojciech Bancik, the coordinator of the American Law Program. Juliana Kobierzyńska, the International Relations Specialist at OXPO, who's been there since its founding almost 20 years ago. Special thanks to Lena Helinska, who designed the beautiful and informative webinar at OXPO. The URL is going to be in the chat. If you haven't looked at it yet, I encourage you to look there. The dates and topics for the first 6 webinars through December are there, and the speakers for the rest of the series from January through early June are there with their bios as well. These webinars are only possible with the crucial support of the Catholic University and the Catholic Law School Development and Alumni Relations Office. Many thanks to Louise Leiden, our Development Director, Kate Smith, our Alumni Director, Jean Emery, the Office Manager, and Pasha Madwani from University Development, who is there with a lovely picture of our law school, who has provided the tech support we need for the registrations and the webinars themselves. Thanks also to our marketing and communication staff, Joe Ferraro, Al Washington, and Jillian Salazzo. Finally, I will mention our LL.M coordinators and graduates, Gaspar Cote and Luc Bartoshik. There will be a virtual information session on our LL.M program on November 4th. At 7 p.m. Polish time. Luke will put the link in the chat, so if anyone is interested in registering for that. So now we turn to what brought you here today, a webinar by our accomplished 2006 LL.M graduate, Dr. Marc Liebscher, on Wirecard, Europe's Enron, Auditor Liability to Investors in Corporate Fraud, followed by comments from our distinguished CUA JD graduate and Board of Visitors member, Christopher Christian. So Mark, if you go ahead and put up your screen share while I mention a few things about how the session will be organized and I introduce Mark and Chris. So most of you are probably Zoom veterans by now. I have already mentioned information placed in the chat. There's a chat button probably at the bottom of your screen. It could be at the top or the side, depending on the device. That's where you are able to type in questions and other comments that you might want to make in the bubble that's at the bottom. You will also see a participants button. If you click on that button, you can see the identifiers of people who have signed on. Also, if you go to the gallery view button on your screen, likely at the top, you can see the screens of those who signed in with the identifiers in the lower left-hand corner. So in addition to the interesting webinar and questions and answers that will follow, you can use the participant list, the screens, and the screen names to replicate at least a bit of the networking that a live event would provide. If the name of your device that appears in the participant list and on the screen is not your name, for example, if it says Leah's iPad, I encourage you to follow the instructions that Kate Smith is putting in the chat to change that. What you do is go to the upper right-hand corner of your screen. There are 3 little blue dots. If you click on that, if you hover and then click on that, it will say rename, and you can put your name in. I encourage you to do that so classmates, colleagues, and friends can see you. And if you're willing to turn on your video, people might also like to see your face and recognize people that they haven't seen for a while. So Marc Liebscher will speak for about 20 minutes. He already has his PowerPoint presentation up. He will be followed by a short comment from Christopher Christian, who will lead off with the questions and answers. As I mentioned before, please type your questions in chat as you think of them. After Dr. Liebscher answers Mr. Christian's questions, I will start to pose questions from the chat to Mark and perhaps to Chris as well. This session is being recorded, and the 60-minute webinar will go up on CUA's YouTube channel within a few days. At the end of 60 minutes, we will close the formal webinar and the recording will cease. Mark and Chris graciously have agreed to stay on for up to half an hour so we can take more of your questions. So we encourage you to stay on if that works. So Pasham, is it possible? I just got a message that someone didn't see participants and didn't have gallery view. If it's possible that we can enable those things so people can see the participant list and see gallery view, that's great. So in the chat, you will now see links for Dr. Liebscher and Mr. Christian. I'm only going to mention a few of the highlights, but you can click on those links in order to get information about their distinguished credentials. Dr. Marc Liebscher is a partner at Dr. Späth and Partners in Berlin, Germany. He specializes in banking, capital markets, and insolvency law, particularly judicial representation of institutional retail investors. He's a member of the expert group of the Federation of German Consumer Organizations on collective redress, and has served as an expert to the German Bundestag on matters affecting market legislation and the introduction of class actions. He's a spokesperson for the Berlin Bar Association's working group on banking and capital market law, an appointed member of the Justice Working Group of Transparency International Germany, and trains senior investigators of the German Federal Criminal Police in financial and capital market matters. He's a 2006 graduate of CUA's LL.M. in American law. Early in his career, as Professor Pichlinski mentioned, Mark spent 8 years in Poland working in various capacities with Jagiellonian and Oxbow. While he will be speaking to us in English today, he also speaks excellent Polish. Christopher Christian is a partner in the Boston office of the Dechert firm and serves on the firm's policy committee. Much of his practice centers on advising US and European asset managers and investment funds and their boards of directors on compliance with US and European law, as well as local law in jurisdictions around the globe. He is the architect of Dechert's World Compass, a marketing compliance subscription service that offers investment firms advice in more than 100 jurisdictions. Mr. Christian worked for several years in Dechert's London office. He's the former chair of the International Bar Association's Investment Funds Committee and was recently selected as chair of the Irish Funds North American Distribution Working Group. Chris is a 1998 JD graduate of our law school and a member of our board of visitors. I now turn the virtual floor over to Mark. Remember to type questions you have in the chat. Thank you. Mark.
Thank you so much, Leah. Thank you for this warm welcome, and special thanks to Jerzy Pisolinski. And I really have to say that the skills that I learned in the Jagiellonian University and later on in the LL.M program at Catholic University gave me the fundament and the possibilities and the skills to work on the level that I've now been working on. Just yesterday and the day before yesterday, I spent the whole day in our Ministry of Finance, where a very high level working group has been established to work on legislative changes after the Wirecard scandal. And I'm proud and happy to say I was the youngest. And that is thanks to the skills and knowledges I acquired in Kraków with Jerzy Pisolinski and at Catholic with Leah. So I'm really happy to be a panelist today and to give you some insights today on Wirecard. I want to introduce you the Wirecard scandal, and I particularly want to focus on the shortcomings of the appointed auditors, Ernst & Young, failures of the German supervisory bodies, and later on, I hope we will discuss with Christopher improvements needed in the regulatory scheme in Germany, and see if some European Union matters will also be possible to address. I want to start with presenting to you. Now my presentation isn't switching to the second slide. Just give me a second. I don't know why that is. I want to start with intro. Here we are. With introducing to you what is Wirecard actually, what is the background, what is this company, what has happened. We can say that Wirecard AG, that's a stock company, produced probably a transformative moment in Germany. It is considered the largest corporate fraud in Germany after World War II. Wirecard is still a Munich-based super fintech company providing payment solutions. That's what it was about, payment solutions. You can PayPal, for instance, these companies. So you can a little bit think about PayPal. And it was member of the DAX 30 in the end. That is considered Germany's most prestigious stock market index. DAX 30, only our most prestigious companies make it to the DAX 30. And it was considered Germany's Apple. So the CEO of Wirecard tried to make his presentations like Steve Jobs did, and the turtlenecks pullover and so on. So it was considered Germany's Apple, and Germany was proud of it like hell. It had a maximum market capitalization of 28 billion euros, but it fell into insolvency in June 2020. So not long ago, actually only 4 months ago. So we're still working on everything what happened, but already now we can say that we have a total wipeout of equity and probably most wipeout of the debt capital. And the damages amount to approximately 20 billion euros plus, can be 30 billion euros, depends on the way you calculate it. And the interesting thing is with Wirecard, we can see, as always, when it comes to these fraud problems, we can see numerous entanglements with the finance industry, with intelligence community, interestingly with the intelligence community, with the administration, media and politics, even with Chancellor Merkel. She was lobbying for Wirecard's entry into the Chinese fintech market and didn't know about the problems surrounding Wirecard. So that has been talked about loudly as well. A short hint to Wirecard's business model. In the start, Wirecard was provided payment solutions for gambling and adult entertainment, short pornography. So whenever you set up an internet shop providing gambling and pornography to your customers, you needed a payment solution so that the payments of your customer, when you provided these services online, somehow reached your account. And in the same time, it had to be sure that your customer received, as soon as he paid or she paid, the services that they paid for. So that was the start of Wirecard. So you already can see a very close fishy link into organized crime. Because gambling and pornography may be legal in some jurisdictions, in other jurisdictions they may not be legal. So whenever in Germany, for instance, gambling is only legal in some parts, pornography is legal almost everywhere in Germany, but in other jurisdictions, for instance, in the US, it's more difficult. So you already can see from the start with Wirecard a close link to crime and organized crime. Later, Wirecard started to acquire credit cards and issue credit cards. So it started cooperating with MasterCard and Visa. And it also started the business of third-party acquiring. I will not go into depth with that. That is easily traceable in the internet. If you want to read more about the business model of Wirecard, you can easily find that. From the start, there have been numerous allegations against Wirecard. From the start, the allegations were, well, they're providing payment solutions for red light and gambling, so a very close link to organized crime. But there always have been numerous allegations regarding the financial reporting of Wirecard, regarding money laundering. For sure, when you provide payment solutions for pornography and gambling all over the globe, other criminally affected businesses will also come to you and ask for your help. So we will come into arms dealing, drugs, child pornography, whatever you wish for. Other allegations regarded the siphoning of funds, inflating the balance sheet, inflating the goodwill, and round tripping. So these allegations have been around against Wirecard since 2008. And these allegations were brought forward by numerous persons. They were brought forward by the media, by short sellers who wanted to made money on short selling Wirecard stocks. They were put forward by analysts, and the whole lot, why I put it the whole lot, perhaps later to that. And very especially, they were brought forward by the Financial Times London by Mr. Dan McCrum, an investigative reporter with the Financial Times London, a very nowadays famous person in Germany, and Germany owes him a lot.
Mark,
because,
Mark,
yeah.
We're getting a little static in your mic, which is making it sort of, at the beginning it was great. So you might
Okay.
move, that's great, but you kind of moved to being cutting in and out a little bit.
Not good, yeah. I will see what I can do, okay?
That's perfect now. What you're doing
Better
now.
now?
Yeah.
Okay. And those allegations have been brought forward also towards Wirecard's auditor, Ernst & Young. So Ernst & Young always had been informed about these allegations. It's Ernst & Young Germany, Wirecard's auditor since 2010. So for the last 10 years, Ernst & Young, with no pause, has been the single and sole auditor of Wirecard. And EY received during all those years numerous allegations against Wirecard's financial reporting, supported with granular data, big stacks of digital data about customers of Wirecard, fake customers, faked shell companies that it acquired, fake shell companies, and that Wirecard made strange acquisitions and widely overpriced acquisitions. So these allegations have all been brought forward to Ernst & Young, and even an internal whistleblower that became public just a few days ago, an internal whistleblower alarmed EY's board in 2016 about Wirecard. So this was an internal whistleblower of EY. So an EY whistleblower alarmed EY's board in 2016 about Wirecard. Hey, things are fishy here, and we are not probably auditing this company. But still, EY signed off Wirecard's accounts with no reservations. So EY always provided an unqualified audited opinion, and the capital market, because of these unqualified audited opinion, always had the impression, well, there may be allegations, and these allegations may be true to some point because the history of Wirecard is closely connected to porn and gambling, and maybe some 2 or 3% of Wirecard's business are fishy, but not everything, because otherwise EY wouldn't have signed it from the accounts. But now that Wirecard has broken down, is in bankruptcy, and things have spiraled out of control, EY obviously faces now massive allegations, lawsuits, and even some commentators say EY Germany faces bankruptcy. So it is clearly obvious to talk about an Enron moment, about what has happened to Arthur Andersen back then. The interesting part with Wirecard are the different supervisory levels. So what has happened with Wirecard has been in the making for a long, long time. The interesting thing about Wirecard is it's not an accidental fraud, as we sometimes, whenever you have corporate fraud, most of the times it's accidental fraud. It means that you slip into it. You have a year that's problematic, your returns are not good as they are, and you start to invent cash balances and so on because you want to hide the problematic turbulences that your business has come into, and you hope the next year I'll make up of it, and nobody will see it. So that is, I would say, from our perspective, 90% of the cases of corporate fraud, that you have a kind of accidental fraud, and you slip into it because you want to hide that you had a not so elegant, not so good year. With Wirecard, it's different. With Wirecard, they didn't slip into it. It has been a fraud from the start, very probably. People are still investigating, but the shareholders association that I am associated with I'm running their Berlin capital office here. We've been investigating Wirecard since 2008, so for 12 years. And we from the start had the impression that this is a fraud from day one. And that's special. That's special about Wirecard. That's a fraud from day one, that it could go on for 15 years and that it could even make its entry to the DAX 30. So that is the special thing probably about Wirecard. And that raises a lot of questions regarding our financial supervisory authorities in Germany. So that is why I want to give you a short glimpse on our financial supervisory authorities in Germany. That is the DPAR and the BaFin, German acronyms. And actually it's a two-tier supervisory system. On the first level, you have the DPR, and on the second level, you have the BaFin. And both institutions are now under huge pressure because both were informed numerous times about the allegations, and they didn't take any action against Wirecard. Investigations from the supervisory authority only started in June 2019, and then only one person was assigned at DPR to investigate Wirecard, and no investigative actions were taken. But on the other hand, BaFin and DPR were very active. They banned short selling of Wirecard shares in 2019. This was a first, and that's a single move we haven't seen in Germany. So they attacked the short sellers against Wirecard shares, and BaFin filed criminal complaints against critics of Wirecard, also against Dan McCrum from the Financial Times. So BaFin, they didn't investigate Wirecard all the time, but they started to attack short sellers, analysts, and investigative reporters of such a renowned, world-renowned media outlet like the Financial Times London. They apologized for that right now, and the criminal complaints have been dropped, but still the damage internationally is done. For sure, there have been failures of other authorities as well since 2008. For instance, the Munich public prosecutor, as I told you, Wirecard is situated in Munich, so that it falls into the competence of the Munich public prosecutor. They received 46 criminal complaints since 2008 with granular data, massive amounts of data, and they didn't take any action. And also our financial intelligence unit against money laundering, they didn't take any action, but still over all the years, they received 2,000 suspect notifications and no action was taken. So we can see massive allegations from day one, and German supervisory authorities and the auditor didn't do anything, no action taken. So the question is, how did it spiral finally out of control? How did it blow up? And I want to switch to the next slide. Let's see if that's. Just give me a second. Okay, it's a little bit slower. So finally, the question: how did it blow up? How blew it up? The problem was, at some point, Wirecard was immune against criticism. I traveled to London a year ago and talked to the major investors in Wirecard, London investors who had 3-digit million euros investments into Wirecard, and I talked not to the portfolio managers but to the owners and senior management of the funds. And they all said, well, it may be true that something is fishy about Wirecard, 2, 3, 5% of the revenues, but not everything, because otherwise BaFin, our supervisory authority, and EY would have found something. We cannot believe that German prosecutors and German auditors and German supervisory authorities are not capable of finding such a massive fraud as you are telling us, Marc. I had 8 meetings with 8 different major investors together. They held some billion euros, and all of them said, well, it cannot be because German prosecutors would have seen it, EY wouldn't have audited it. they just couldn't imagine that this is possible, and kind of reminds me of the things that happened in 2008 with the financial crisis. It cannot be, right? But at some point, the pressure on Wirecard was growing and growing, and thanks to SoftBank, Japanese tech investor, the largest Japanese tech investor, SoftBank, they put pressure on Wirecard's supervisory board, and in November last year, Wirecard supervisory board commissioned a special forensic report by KPMG. And this forensic report by KPMG was released finally in April 27th of that year, so 6 months ago. And this report is 75 pages long, and a lot of information. And the major information was the cash amounts that Wirecard accounted of the amount of 1.9 billion euros couldn't be found. So they couldn't find any evidence of cash in the amount of 1.9 billion euros. That's quite a number for cash. We're not talking revenues or something. We're talking cash on bank accounts that was missing 1.9 billion euros. They didn't find that. And that was the knockout. That was the start of Wirecard's collapse. And within days, not within months, went on until the 18th of June, because on the 18th of June, some facilities were due, and it quickly spiraled out of control, and was the start of Wirecard's collapse. So now in Germany, we are looking at where we're standing here, and we're standing in front of a catastrophe, and we're reckoning what to do and where to turn to. And there are several things that now the German regulator is thinking about. He's thinking about legislative reforms, reforming the supervisory mechanism, and they are addressing the accounting firms, especially the big four. As you all know, we have an oligopoly of KPMG, PwC, PwC, EY, and the fourth. I'm missing the fourth, sorry, but you know the big four. And this oligopoly, they want to, somehow they have to reckon with that. Besides of that, there are numerous investor lawsuits against EY. We have filed the first lawsuits against EY, the most numerous lawsuits, several class actions, so far hundreds of investors. We're representing several 10,000 of investors against Wirecard. And these lawsuits we are filing against EY. There's no sense in filing lawsuits against Wirecard because Wirecard fell into bankruptcy. There's no money to be found there. You could file lawsuits against the board of directors of Wirecard, but they're private funds, and by far not sufficient for the damages the investors incurred. So there's no sense in filing lawsuits in the billions against the board of directors. So far, the best shot you can get is filing lawsuits against EY. And these lawsuits are based on, for our Polish friends, I know that you're very close to German law, and most of you also attended German law school. So it's paragraph 826 of our German Civil Code, BGB, immoral damages. The German term is vorsätzliche sittenwidrige Schädigung, special thing. And the reason for that is that we hold inter alia numerous shortcomings of EY, but one of the major shortcomings is that EY violated its obligation to obtain balance confirmations for material cash positions. So the missing 1.9 billion, so-called cash equivalents. And EY should have obtained these confirmations directly from the banks managing the accounts. And that is the starting point for the lawsuits that we have filed in the court of Stuttgart. Stuttgart is where EY Germany is incorporated, and that's the reason why we filed these lawsuits with the Regional Court in Stuttgart. So this is a short introduction into Wirecard, what it was, what has happened, and how it blew up, and what is happening right now. I think with this short introduction, you can easily work and have an idea what has happened, and I would be happy to answer any questions, and I'm looking forward to the discussion. Thank you.
Thank you so much, Marc. And we now turn to Christopher Christian, who will make a short comment and also lead off the questioning. So as Chris is talking, those of you who are participants, please think about what your questions are and start to put them in the chat. Chris.
Thank you very much. And thanks, Marc, for that excellent presentation. The title of your presentation was Wirecard, Europe's Enron. And you made a number of similarities and references to Enron. And it really is striking how similar these two cases are. And for those of you who are not familiar with Enron, which happened really almost 20 years ago, Enron was an old line energy company based in Houston, Texas. And it really specialized in owning and producing electric power facilities early on. And in 1985, essentially Houston Natural Gas merged with Internorth, two Houston-based companies, to create Enron. And shortly thereafter, it stopped becoming a power production company and an oil and gas company, and really repackaged itself into an energy trading company. And its business model really changed from power delivery into basically a financial services firm. And it entered into a lot of derivative contracts and other contracts for the future delivery of some sort of power, whether it's electric, oil, gas, water, solar, at some future delivery date, and really kind of reinvented itself. And for a period of 6 or 7 years, it was named by Fortune as one of the most innovative companies in America for 6 years running, up until its collapse. And in 2001, Enron historically collapsed. And at that time, the market capitalization was 29 billion US. So it's interesting, Marc mentioned it was 29 billion euros, the market capitalization of Wirecard, very similar sized companies, even 20 years later. And at the time of Enron's collapse, there were more than 28,000 employees in the United States. So 28,000 employees soon lost their job in what then was the largest US bankruptcy in our country's history. So really, really historic. And it really centered on a couple of the similarities we see with Wirecard, including, as Marc mentioned, suspicious transactions, right? Inflated balance sheets, really a lot of corporate accounting that went wrong and was, quite frankly, fraud. And so, Enron blew up. It had a market capitalization again of 29 billion US. That went to zero. The stock price on the last day it traded had gone in a period of days, so very similar to Wirecard, how it collapsed in a matter of days, went from $90 a share to $1, and then trading was halted. So really historic collapse, and doors closed, and then change happened. And what we see post Enron, and we'll get into this in a minute, and asking Marc some questions, was really a dramatic change in corporate America. Fundamental change. And there was a fundamental change in corporate governance, which was really the start. That was ushered in with the Sarbanes-Oxley Act in 2002. And that really fundamentally changed corporate governance in America, including requiring a majority of directors on boards of public companies to be independent. It was a big step, kind of a check and balance of corporate greed. And there were a lot of other major changes that happened in really 5 areas. The first area, I think, was accounting oversight, and it'd be interesting to see what happens in Germany. And the US really had a new public company accounting oversight board that was created to kind of watch the big five at that point. And Arthur Andersen, who was watching the store for investors and didn't watch the store and is now bankrupt itself. Corporate governance and listing standards. So this was a listed company in Germany. Enron was an NYSE listed company. The listing standards for the NYSE dramatically changed, and there was a lot of focus on substance, corporate governance, and new standards. Disclosure reform, real-time disclosure reform of financials was ushered in by the SEC, and most notably whistleblower reform. And Mark noted there were whistleblowers, a number of whistleblowers in this case, that were seemingly ignored. And that was the case in Enron. There were some whistleblowers that had come forward in Enron and blown the whistle and were kind of swept aside. And I remember when I was a more junior attorney at our offices about a block from the White House in Washington, D.C., the barrage of FBI agents in their FBI jackets that had come in with the SEC into a conference room and camped out in our offices for about a month and interviewed a whistleblower who had turned state's evidence against Enron post its collapse. And they were fascinated for a month about what they were told. Off-balance sheet transactions, special purpose vehicles in the Cayman Islands, hiding of credit risk, right? Suspicious transactions, loss of money, really all things that we just heard from Mark 20 years later in this case. And I guess, Mark, my first question to you to get the discussion started, it really is, you know, in America, we saw a rash of reforms, both at a regulator level as well as a corporate governance level. Do you think some of the similar type reforms will take place in Germany? And you kind of alluded to them here on this slide, but maybe you could comment on that. Do you think there'll be accounting oversight or more corporate governance? How do you think that will play out?
Yes, thank you so much, Chris, for your remarks. I also have checked into the chat, the questions there. So I will first try to answer questions that Chris raised, and then I will try to ask some of the questions I could pick up from the chat. The interesting thing is that our two-tier supervisory mechanism that was established after Enron. So that was a reaction to Enron scandal, to the Enron scandal. So our supervisory and accounting auditing regime was already built after the Enron scandal. And the interesting thing is it didn't prevent our German European Enron scandal. So we have identified the major problems, I guess, with our supervisory mechanism. Actually, the problems, it's Groundhog Day. It has been around all the time, but the major problems are probably cultural problems. We have a very strong coziness between our supervisory authorities and the supervised companies. They live a culture of friendly cooperation, and they have a reluctance to intervene. That is due a little bit to German stakeholder capitalism, no conflicts, but work together. The second point is probably BaFin. We are convinced they are understaffed, under-talented, under-ambitious. It's really not sexy to work for a supervisory mechanism, for supervisory authority in Germany. They don't pay well, you are not well regarded, there's no prestige, nobody fears you. It's not like the SEC running around with flak jackets and the Federal Bureau of Investigations, FBI in the US, and making a hell of an impression. These are just bored, under-talented bureaucrats. So BaFin cannot and has never attracted talented or ambitious staff. Another problem were the unclear responsibilities between the DPR and the BaFin within this two-tier system. The responsibilities were not clear, and now everybody's doing the finger pointing at the others, right? So I wasn't responsible, they were responsible, and they are answering, no, not we were responsible, they were responsible. So the responsibility is round tripping. And that is a problem as well. And from the English point of view, the Financial Times stresses that as well. It has been a point of German patriotism, because most of the short sellers and the analysts that were critical about Wirecard in the beginning were from London, and somehow German patriotism got the upper hand against Anglo-Saxon short sellers who envy Germany for their great company Wirecard. And this all has come down and is in shambles now. And the proposed solution that the German legislator is discussing right now is a better funding for BaFin and for the supervisory authorities in Germany, and to enable BaFin to attract top-level staff. Nobody knows how to do that because we are paying our bureaucrats alongside the German bureaucratic norms, and you get some 60,000, 70,000 euros max, and that's about it. And the people you would need there should earn more than our chancellor if you want to attract top-level staff. That will be a problem. Second thing is we have to be clear about the different responsibilities in this two-tier system between DPR and BaFin. So we have to rearrange, rebalance that. And we will need a low threshold for forensic examinations by BaFin. As I said before, BaFin was reluctant to intervene and didn't see conflicts with the supervised companies. BaFin should seek these conflicts and have a very low threshold to intervene and to start forensic examinations of supervised companies. And you should hire the know-how in BaFin. One thing that BaFin always did when they investigated companies, they hired outside knowledge for the investigation. So they hired KPMG to investigate a company that was audited by EY. So what happened is this whole oligopoly again was checking itself, and there were no checks and balances. So you would have to make sure that the know-how stays and is allocated within BaFin. And overall, you would have to change the mindset and the culture of BaFin completely. Transparency is another issue. We are discussing to make BaFin investigations, not only the findings, but the investigations already public. And one interesting thing also is that we are discussing to abolish BaFin's exemption from state liability. Interestingly, BaFin is the only state authority in Germany that is exempt from state liability. Even our Bundeschancellor is not exempt from state liability. So when Chancellor Merkel makes a mistake, she will be liable for that, but not BaFin. And we all know liability produces responsibility and responsible behavior. So one thing that is really important is to abolish BaFin's exemption from state liability. That would be the reforms and the problems and the reforms that we found out on the level of the supervisory authorities. Another question is
Marc, just wait a second. If you're finished with the slides, if you could take them off SlideShare. And actually, I'm going to ask you the questions in the chat because I'm also sort of managing the time a little bit. I know you were using the slide to respond to Chris's question. If you're finished with the slides, you can take off screen share now. We have about 10 more minutes. And so I'm going to take the first 2 or 3 questions in the chat and pose them to Marc. And then we, at 1 hour, are going to close the recorded part of this. Marc and Chris graciously have agreed to stay on for another half hour. So we will be able to take additional questions, but we will cease the recording. And if any of you have to leave us, of course, we will be grateful that you were here. So Mark, the first question that we have is from Professor Duggan, whose question is, did Wirecard have an internal compliance function or other internal oversight and monitoring mechanism? Now that of course relates to the fact that next week's webinar, because Professor Duggan is the head of our Compliance, Investigations, and Corporate Responsibility program. And our next week's program, in fact, is going to deal specifically with compliance programs. So the question is to you, Mark.
Thank you. Thank you for that question, Sarah. I very well remember the course that I took with you 20 years ago at the Jagiellonian. So great to get this question from you. Wirecard did have an internal compliance function. They had an oversight and monitoring mechanism. They even had a whistleblower mechanism. But all these mechanisms ended up at the board of directors. And the board of directors, as you see this person here behind me, they are sought after by our FBI, fraud in the billions. These are the guys who were responsible for the fraud. So all these compliance functions and oversight and whistleblowing functions, they ended up with those people who were responsible for the whole scheme. So that was the problem with Wirecard.
Great, thanks. Then we have a question from Mateusz Bogilski. What is the requirement under German law to rotate external auditors? In Poland, he recalls there is a requirement.
Yeah, they have to rotate. We differentiate between banks and insurance companies and other companies. Financial companies, so bank and insurance companies, they may be audited by the same auditor for a maximum of 10 years. So 10 years for financial companies. All other companies must rotate after a maximum of 24 years. So financial companies 10, other 24. So the need for rotation is not huge.
So there's a question from Eric Hirschhorn. Was there collusion with insiders at EY or the German regulators, or were they merely asleep at the switch?
Yeah, if we knew that, we would be made men. I cannot imagine, we cannot imagine, all the lawyers I've talked to, and we are fighting the German supervisory authorities and we want to make them liable for that and everything. We cannot imagine that there was collusion between Wirecard and the German regulators. That is that is unthinkable. It would be a shock to us. The reason they were asleep, yes, they did protect Wirecard because they thought, well, the Anglo-Saxon short sellers are attacking our German crown jewel and that's not good. And they didn't understand it. They were stupid. They were asleep. Yes, I think we can easily say that was the case, but we do not have any indications for collusion between Wirecard and the state authorities. One interesting thing, though, is Wirecard had very close ties to the German intelligence and European and Russian intelligence community. Why that? Nobody understands why those close ties to the intelligence community. Jan Marsalek here, the CFO of Wirecard, he's under the auspices of the Russian military intelligence in Moscow. And that is a question people are running after. And we think it could be possible that Wirecard, having so much knowledge about incriminated payments, they knew who was buying what porn tapes. And that is interesting. If you want to know which prince from which country is looking at what porn, Wirecard could be of interest for you because they knew where the money was going and they had the customers relations. So that could be an interesting thing. Collusion between Wirecard and Ernst & Young, we think yes, but we haven't found the smoking gun yet. So there's no evidence for that, but a lot of hints, and probably at some point in the future, Dan McCrum from the Financial Times or somebody else will come up with something. So far, no evidence for that, but we are suspicious because the risk EY took on completely outweighed the money they were making from it. They made some 1.5 million euros for the auditing of Wirecard per annum. And the risk they took was immense for that. So thanks for that question, Eric. Collusion with EY, probably no evidence so far. With German state authorities, probably not.
I think we're probably going to have time for 2 more questions on the recorded session. We'll then turn off the recording. And again, we'll have then another probably at least 25 more minutes. So there's a question from Piotr Koziec that says, was the problem not enough procedures or that the procedures had not been observed, particularly in the context of legislation after 2008 crisis?
No, probably both. BaFin had enough hints, BaFin had enough remedies and investigative matters and skills and powers to stop what took place already 10 years ago. But BaFin didn't have the will. It's a cultural problem. You have to have people who are coming into their office and say, well, I want to do my job. I'm here to investigate companies, to do some oversight. And I'm not here to enter into a friendly cooperation with the supervised companies. So thank you for the question, Piotr. But I think the regulation is one point. The culture, the willingness to do things, that was lacking. And for sure, German politics are now saying, well, it's been a problem of procedures and of law, because they don't want to be responsible for the shortcomings that have been there while everything was in place that was needed, right? So that is why in the public debate, the politicians are very much trying to emphasize we had shortcomings on the legal level, on the law level, but actually it's more shortcomings on the cultural level.
Okay, for a final question in the recorded session, I'm going to take the question from Wojciech Jaroszyński, who is one of our speakers in November, and then we will again have some more time after that. Do German claimants have a procedural tool to request EY to produce evidence to support their claims against EY?
No, and that's a huge problem. No discovery, nothing. German claimants must find all their evidence themselves. And that's always a huge problem when you are suing an auditor of a company, because as a claimant, you do not have access to anything. Now, what is the special situation here is that KPMG was commissioned by the supervisory body of, by the supervisory board of Wirecard. KPMG was commissioned to produce this report. A 75-page report I told you about earlier, and this report is public, and that is something that's very helpful for the claimant in this situation, because we have a very detailed report of KPMG about the shortcomings of Wirecard and thus the shortcomings of EY's auditing. So this is helpful in this case, but normally these cases are very, very difficult to win because you lack evidence.
Okay, Mark, at the very end of that question, we were having the static problem again. So you want to sort of work on that. So we are now going to actually turn off the recording function. And for any of you who had just budgeted an hour and need to go, we're very glad you joined us.